So today I'd like to talk about breed-specific legislation and specifically in relation to dogs. So breed-specific legislation has been introduced in the UK through the Dangerous Dogs Act of 1991. And this legislation targets dogs that are effectively banned. And the bill was introduced in response to a number of dog attacks, particularly dog attacks on children by breeds who are thought to have been trained to be used for fighting. And the bill was published and went through all the procedures in Parliament very quickly, and it subsequently attracted some criticism. So there is a number of pieces of legislation that relate to dog control. For example, not just the Dangerous Dogs Act, there was the Dangerous Dogs Amendment Act in 1997. There is the Dogs Act of 1871 that deals with civil measures to tackle dog incidents. There are provisions in the Antisocial Behaviour, Crime and Policing Act of 2014 and the Dangerous Dogs Exemption Schemes Order of 2015, which supplements the Dangerous Dogs Act. There's a Dogs Protection of Livestock Act of 1953. And the Animals Act of 1971 sets out provisions relating to civil liability for damage caused by dogs. But the breed-specific provisions of the Dangerous Dogs Act can be found in Section 1, and these apply to the Pit Bull Terrier, or a dog of the type known as the Pit Bull Terrier, a dog of the type known as the Japanese Tosa, and then by secondary legislation also included has been the Dogo, Argentino and the Fila Brasileiro type dogs. And these are not recognised breeds in the United Kingdom, and there is no statutory definition of this breed. And what makes it quite problematic for people who have dogs that may or may not be of this type is that Section 5.5 of the Act actually reverses the burden of proof, so that if it's alleged that a dog is of the type listed in Section 1, so one of those 4 types of dog breeds, the onus falls upon the accused to show that it's not of that type. So what are the prohibitions on Section 1? There are prohibitions on owning or possessing a banned breed, on breeding from such a breed, selling or exchanging or offering as a gift any one of these breeds. And also these dogs should be kept muzzled and on a lead, and those dogs should not be allowed to become stray. Now, there is an exemption scheme that can be found in the Dangerous Dogs Exemption Scheme Order of 2015, and this enables to keep those prohibited type dogs as long as they're registered on the index of exempted dogs. And as of 2018, the government's figures show that there were 3,530 dogs on the index. And there are various conditions that apply, such as the dog should be neutered and microchipped, there should be third-party insurance, and there are other such conditions. So the 2015 exemption scheme does allow for a change of ownership if someone dies or they can't keep a dog due to a serious illness. But otherwise, there are no provisions for transferring ownership. Now, if a dog's on the index and is abandoned and taken in by a rescue centre, as the court has already proved that dog, someone else may be approved as being responsible for the dog. But stray dogs who have not previously been on the register, who come into the care of rescue homes, find themselves vulnerable because there is no legal power to rehome those dogs, and so they're usually euthanised. And that can include puppies, and that can be distressing for the people involved in the euthanasia, and also raises real welfare concerns about killing dogs who might actually be of a good temperament. Now, the Dangerous Dogs Act covers more than simply the Section 1 dogs, the prohibited breeds. Section 3, which provides controls in relation to dogs who exhibit dangerous behaviour, applies to all breeds of dogs. So it's only Section 1 that relates to these banned breeds. So is breed-specific legislation justified? And in my opinion, when considering this, there are 3 big headline questions that should be answered. What's the cost to the public purse? What's the economic cost? What are the costs in terms of dog welfare? And what are the benefits in terms of preventing dog bites and attacks, keeping the public safe? So when it comes to the question of public policy, how best to protect the public from dog attacks, I think you have to ask the questions, are some dogs inherently dangerous? And so one has to look at the science behind that. Can the level of behaviour be determined by breed or by upbringing or by some other factor? And what are the alternatives to breed-specific legislation, i.e. these laws that apply only to specific breeds? And when we look at the benefits to society, I think we have to ask, does the scientific evidence support the case that some breeds are inherently more aggressive? Does it support the fact that breed-specific legislation achieves the desired result of reducing the dog attacks on people? And how can we measure this? Does it give false assurance about the level of risk posed by non-banned breeds? And when we measure the effectiveness of breed-specific legislation, it can be useful to look at studies from other countries, including those countries who adopt alternative approaches. And in some states in America and in some European countries, there has been a reversal of breed-specific legislation. And an RSPCA report, Breed-Specific Legislation, A Dog's Dinner, published in 2016, cites studies in Ireland, Spain, Italy, Netherlands and Belgium showing no reduction in bite numbers as a result of breed-specific legislation, and only a reduction in Manitoba, although it was pointed out that there were some limitations with this study. Schaffner, in her book, An Introduction to Animals and the Law, cites two studies, one in the UK in 1996 and one in Spain in 2007, which compared the number of dog attacks and dog bites in the period before and after breed-specific legislation was enacted, and those found no reduction significantly in the number of dog attacks. Another approach is to actually look at the predictive factors involved in dog bites. So for every dog bite, some analysis is carried out of the factors behind it. One such study that looked at 256 incidents between 2000 and 2009 found that the predictive factors included factors such as no able-bodied person being present to intervene when a problem arose, a failure to neuter or spay the dog, the victim's compromised ability to manage interactions with the dog, prior mismanagement, abuse or neglect of a dog. And so these are the sort of factors that the study identified. And when we look at the cost to the public purse and that aspect, I think those economic costs associated with breed-specific legislation would include caring and housing for detained dogs during the trial process, veterinary and euthanasia costs, and the costs of litigation arising from disputes about whether a dog is of a banned type or not. The welfare costs for dogs would include those dogs being housed in kennels for prolonged periods as cases progress through the courts, larger number of dogs being seized to determine if they are of a banned type or not, and the destruction of dogs who might not actually represent a danger to the public. So what are the alternative approaches to breed-specific legislation? Well, there are laws that actually target dog behaviour, targeted at the demonstration of aggressive behaviour where it occurs, and those approaches that target the owner behaviour and deal with the issues such as ownership and control, perhaps through disqualification orders and orders after a court case for further training, which we'll come on and discuss. And there are also non-legal approaches such as public education. So this is an issue that's been examined very recently by the Select Committee, whose report in January 2019, Controlling Dangerous Dogs, has examined this very issue about breed-specific legislation. And what they have said is that although the government has maintained that a breed ban is essential to public safety, arguing that prohibited dogs pose an inherent risk, our inquiry found insufficient evidence to substantiate this claim. And they found that the current approach to dog control is plagued with deep structural problems. So what were their recommendations? They recommended that the government should immediately remove the prohibition on transferring a banned dog if behaviourally it was assessed and found to be safe. They recommended that the government commission independent expert evidence to establish whether banned breeds pose an inherently greater risk than other breeds. They recommended a comprehensive review of existing dog control legislation and dog awareness training for school children and targeted awareness campaigns for dog owners and the public on safe human-dog interaction. So really supporting that very science and evidence-based approach to policy. Their recommendations also included mandatory training and education courses for people convicted of minor dog offences, and for future strategies to be developed with a commitment to evidence-based medicine, which we can see from their earlier recommendations, and increased support to local authorities and police forces to ensure they have the capacity to fulfil their duties, and engagement with international partners to learn lessons and best practice from abroad. So what have the government said about this? Well, the government has pointed to research that they have commissioned with Middlesex University to look at the effectiveness of current dog control measures, including the factors and situations causing dog attacks and how best to promote responsible dog ownership. In relation to the change of ownership provisions, the government has said that allowing prohibited dogs with no previous court-appointed owner to be transferred or rehomed to someone with no previous contact with that dog would require primary legislation, and at this time it's not a priority to amend that legislation. And they pointed out that they would need time to consider the implications for public safety, any increased burdens on the court, and the implications for rescue and rehoming centres. And they have said that licensing of rehoming centres would be a necessary prerequisite before taking those further steps. In relation to the criminal justice system, they point to the fact that the Metropolitan Police Service has set up a data collection system, and the government is keen to explore with the National Police Chiefs Council and other police forces how such data can be collected more widely to give an accurate national picture. And speeding up court cases so that it minimises the risk of dogs being kept kennelled for very long periods of time. The government points to a scheme in London where there is a single magistrates court for hearing dog-related cases, and that has had the effect of reducing the time for these cases to be dealt with and has enabled expertise to be built up, and they're considering whether this model can be rolled out to other parts of the country. Other strategies in relation to, for example, education and dog training methods. They're awaiting the results of the further research that's being carried out, and they point to the fact that there are already some powers under the Antisocial Behaviour, Crime and Policing Act of 2014 and other legislation to require dog owners to attend dog awareness and training courses. So this is not a subject that's going to go away. There is likely to be further scrutiny of this issue over the months and years as the research develops and further pressure is put on the government to look at the specific provisions that are breed specific and whether they can be softened, amended or dispensed with in order to meet those very real welfare concerns about the dogs concerned.